Deputy handcuffed black man outside his own law firm. Partner walked out with the sheriff's boss on the phone. The handcuffs went on at 9:14 in the morning, not in a back alley, not in the ambiguity of a high-crime neighborhood at an uncertain hour. On the front steps of a four-story building on Garrison Avenue in Fort Worth, Texas, in full morning light, while foot traffic moved past on both sides, while the coffee shop across the street was doing its peak hour business, while a man in a suit carrying a litigation bag had just pressed the code to unlock the front door of the building he had been entering through this door, in this suit, with this bag, for 11 years. The deputy's name has been through a process, which will be described in its time. The man in the handcuffs is named Cornelius Vance. He is 52 years old. He is a partner at Vance, Ashford, and Osei, a civil litigation firm that has occupied the third and fourth floors of this building on Garrison Avenue for the past 7 years. He has litigated 114 cases to verdict in the state of Texas. He has argued before the Fifth Circuit. He has a framed photograph on his office wall of himself shaking hands with a governor, which he keeps not as a monument to status, but because his mother asked him to put it somewhere she could see it when she visited, and that is the wall she can see. He had been outside the building for approximately 90 seconds when the deputy arrived, not in response to a call, not as a consequence of any report or complaint. A patrol deputy for the Tarrant County Sheriff's Office, making what he would later describe as a routine area check, who had observed a man in a suit standing on the steps of a building and had made, in the time between observation and approach, a series of decisions that his training did not require and his supervisors had not authorized. He had asked for identification. Cornelius had said, "This is my building. I work here." The deputy had said, "I'm going to need to see some ID." Cornelius had reached into his jacket and produced his Texas State Bar identification card, which bears his photograph and his license number and the words, "Licensed Attorney in the State of Texas." The deputy had looked at it. He had asked, "Any other ID?" Cornelius had said, "My driver's license is inside. I was about to go in." The deputy had said, "I need you to stay here for a moment." Then the radio, and then 2 minutes, and then the handcuffs. Cornelius Vance did not resist. He did not raise his voice. He had spent his professional life understanding what resistance costs and what it buys, and in this moment, on these steps, with a deputy who had already made the decisions he was going to make, resistance was not the instrument available to him. He was still. He was steady. He looked at the traffic on Garrison Avenue, and he breathed, and he waited. What he was waiting for, though he did not know this in the specific sense, was the door behind him to open. It opened at 9:17. The person who came through it was his law partner, a woman named Adaize Osei. She was holding her phone to her ear, and she was not talking. She was listening. She listened for 4 more seconds after she came through the door. Then she looked at Cornelius in handcuffs on the front steps, and she said, into the phone, with the precise, flat delivery of someone stating a fact for the record, "I'm looking at him right now. He's in handcuffs on the front steps of our firm." The voice on the other end of the phone was the voice of the Tarrant County Sheriff. The handcuffs came off at 9:21, 7 minutes. 7 minutes of a man who had spent 31 years becoming the person standing on those steps, who had crossed every line the system had drawn and earned every credential it had offered, who had pressed the code to a door he owned a stake in, and had still ended up in handcuffs on the wrong side of a deputy's assumption. Nobody outside that building yet understood what those 7 minutes were going to become. Nobody knew that the woman who had walked out with a phone to her ear had been on the phone with the sheriff for 4 minutes before she came outside, because she had seen through the office window before Cornelius had been stopped, had understood what she was looking at, and had made a call before the situation on the steps finished assembling itself. Nobody who had walked past on Garrison Avenue knew yet that the man they had seen in handcuffs was the man whose name was on the sign above the door. Subscribe and tell me where you are watching from. Now come back with me. Not to Garrison Avenue. Much further back to where 2 people built a partnership that made it possible, on a September morning, for one of them to walk out with the right phone call already in progress. Cornelius Vance grew up in Houston, Texas, in the 5th Ward, in a neighborhood that had been systematically underinvested in for so long that the underinvestment had become the texture of the place, the grain of the wood, the thing that was there before you started looking, and that you had to decide whether to accept as a fixed condition or reject as a choice someone had made and that someone else could unmake. His grandmother, a woman named Ida Mae Vance, had made the second choice for 63 years without calling it that. She had simply refused, in the practiced, daily, specific way of certain women of a certain generation, to accept that what was in front of her was what it had to be. She ran a childcare operation out of her home on Leland Street for 38 years. Not a licensed facility in the formal sense. In the years before the licensing requirements existed, and then in the years after, when she obtained the license because she had been doing the work correctly and there was no reason not to make it official, she had cared for 114 children over those 38 years. Not consecutively. Overlapping, in the way that small children overlap when you are caring for multiple families, multiple schedules, multiple particular needs. Cornelius was among the first. He was 2 when he arrived at Ida Mae's on Leland Street, and he grew up there as much as he grew up anywhere, in the specific double life of a child who has 2 homes and who absorbs the culture of both. His own home was his mother's, a woman named Patricia who worked as a court reporter and who came home every evening with the transcribed record of a system she participated in from a position that was essential and invisible. Simultaneously, and who had formed, from years of transcribing the proceedings of judges and attorneys and defendants, specific and clear views about what the law was and what it was supposed to be, and the distance between those two things, which was considerable and navigable, and the navigation was what mattered. Patricia did not tell Cornelius to be a lawyer. She told him to understand the system before he decided what to do with it, because understanding it was the prerequisite for anything else. She brought home, when he was 12, a copy of a closing argument she had transcribed that week, not the verdict, just the argument, and she sat at the kitchen table with him and read it with him, and asked him questions about it. Not what the lawyer had said, what the lawyer had intended, what the argument was trying to make the listener feel and believe and decide, and how the language was doing that work. Cornelius was 12 years old, and he understood, reading a closing argument at a kitchen table in the Fifth Ward of Houston, that the law was a language and that the people who spoke it fluently had access, that the people who did not were routinely denied, and that the access was the power, and that the power was available to anyone who learned the language, and that learning it was the work. He went to law school at 25, after 3 years working as a paralegal at a litigation firm in downtown Houston, because he had decided in the deliberate, unhurried way of a person who has been building toward a decision for longer than the decision itself takes, that he wanted to understand the system from the inside, from the floor up, from the files and the motions and the discovery responses and the depositions before the arguments, so that when he made arguments of his own, they would be built on the complete foundation rather than the top layer. He had been an excellent paralegal. The partners at the firm where he worked had twice offered him an accelerated path to a senior paralegal role. He had declined both times. He wanted the law degree. He wanted the credential that matched what he already knew, because he had learned from Patricia that the credential was the key to the room, not the knowledge, and that the people who knew but did not have the credential were the people the room had permission to overlook. He went to law school on a partial scholarship, and a loan he repaid in 11 years. He was third in his class. He was not the student who performed most visibly. He was the student who, when a professor called on him, had clearly been thinking about the question from more angles than the question required, and whose answer addressed the question and then continued past it to where the question was pointing. One of his law school classmates was a woman named Adaize Osei. She had grown up in Dallas, the daughter of a Ghanaian engineer named Bernard, a different Bernard than the one who had given Diane Okafor her Saturday mornings, but a man of the same generation and the same formation, the same understanding that you design structures to bear more than anyone expected. Her mother, a woman named Cecilia, had been a litigation paralegal for 20 years before law school and had brought to the classroom the same floor-up knowledge that Cornelius had brought from his own paralegal years, so that when they ended up in the same first-year contract section, they recognized each other in the specific way of people who have arrived at the same place by parallel roads. They studied together. Not because they agreed on everything they argued, regularly and productively, the way people argue when they trust each other's intelligence enough to push. Adais argued from principle first. Cornelius argued from precedent first. The collision between their approaches produced, over 3 years, a kind of thinking that was better than what either of them produced alone. Because the principle without the precedent is aspiration, and the precedent without the principle is procedure. And neither alone was what they were after. What they were after was winning. Specifically, winning for people who walked into legal situations without the language and found themselves at the mercy of a system that the language governed. They graduated and went separate ways for 7 years, Cornelius to a firm in Fort Worth, Adais to public defense in Dallas, and then to a boutique civil rights practice in the same city. They stayed in contact, the way people stay in contact when they have been through the formation years together, and the contact is the connection to who they were becoming during those years. They talked about the work. They argued about cases. They sent each other articles and briefs, and the occasional scathing review of an opposing counsel's motion. On a Thursday evening in January, 11 years before the morning on Garrison Avenue, Adais called Cornelius and said, "I want to start something," he said. "Tell me." She told him. A civil litigation practice focused on institutional accountability, specifically, the accountability of systems that produced harm through design rather than incident, through policy rather than accident. Not exclusively, but centrally. The cases other firms found uneconomic because the plaintiffs were not wealthy and the defendants were institutions. The cases that required the specific combination of principle and precedent and the willingness to build an argument from the floor up. He said, "I've been thinking about this for 2 years." She said, "I know. I've been waiting for you to say it." They opened Vance. Ashford and Osei the Ashford was a third partner who joined 6 months later, and whose name belongs in this story but whose contributions deserve their own telling. On the first Monday of the following March, in a 2-room office on the second floor of a building on West 7th Street in Fort Worth, Cornelius pressed the code on a door that was not yet theirs to own, but that they were already working to make theirs in every way that mattered. They worked. The firm grew in the specific way that firms grow when the work is good and the reputation is earned rather than marketed. Their first 3 years produced 11 cases that settled and 2 that went to verdict. Both verdicts were won. The second verdict, a civil rights case against a municipal agency that had systematically denied permits to minority-owned businesses in a majority-minority neighborhood, produced a judgment that was covered by 3 regional newspapers and 1 national legal publication. The coverage was not what the firm had been working for. The coverage was a consequence of the work being what it was. By the 7th year, the firm had expanded to the 3rd and 4th floors of the building on Garrison Avenue. They had 12 attorneys. They had established a pro bono program that provided civil legal services to clients who could not pay, structured around the principle that the access to legal language should not be determined by the ability to pay for it, which was Cornelius's articulation of what his mother had been showing him at the kitchen table when he was 12. They had won 41 cases to verdict. They had settled 63 more. They had argued before the Fifth Circuit twice, once successfully, once on appeal that was still pending. They had been named to a regional legal publication's annual list of notable civil litigation firms for 4 consecutive years. On the morning of the incident, Cornelius had been in the office until 11 the previous night, preparing for a deposition scheduled for 10 a.m. He had gone home at 11:15 and returned at 8:45, earlier than his usual 9:30 arrival, because the deposition required a document from the file room that he had realized on the drive home he should review one more time. He had pressed the code on the front door at 9:12 a.m. The door had not yet closed behind him when the deputy had appeared. He had been outside the building for less than 2 minutes. The litigation bag he was carrying contained the documents for the deposition. The suit was the suit he wore on deposition days. Not his best, that was for trial days, but a good one, charcoal, pressed. with the specific quality of a garment that had been chosen for what it communicated in a room where what you communicated mattered. He had dressed for the deposition. He had not dressed for an encounter on the front steps. He had not anticipated needing to. When the handcuffs went on, he breathed and he waited, not because he did not know what was happening, because he knew exactly what was happening, and he knew that the next decision he made would shape every subsequent decision in this situation, and that the next decision was to stay still and let the situation develop and be available for what would come, and what would come from inside the building behind him, because there were people inside the building who knew what this was. At 9:15, through the third-floor window, Ades Osei saw Cornelius on the steps in handcuffs. She had the sheriff's personal number because she had been on the opposing side of a case involving the county's detention facility 18 months ago, a case that had involved 7 months of discovery and 2 depositions of department leadership, and the case had settled, and the settlement had included a policy change that the sheriff had implemented personally, and in the process of implementing it, he had called Adais directly to discuss the implementation language, and had given her his cell number in case the language required clarification, and she had stored it the way she stored everything. That was worth storing with the specific attention of a person who understands that the relationships you build in adversarial processes are sometimes the most durable ones, because they have been tested by the process and have survived it. She called him at 9:15. He answered on the second ring. She said, "This is Adais Osei at Vance, Ashford and Osei. My partner Cornelius Vance is being detained outside our office by one of your deputies. Mr. Vance is a licensed attorney who was entering his own building when this deputy stopped him. He has produced his Texas bar ID. He has not been given a reason for the detention. I need this resolved." The sheriff said, "Where?" She said, "Garrison Avenue, front steps." She heard him pick up a radio. She walked to the front door. She walked through it at 9:17. She was still on the phone, listening to the radio traffic. She looked at Cornelius. She said into the phone, "I'm looking at him right now. He's in handcuffs on the front steps of our firm." The response on the other end of the phone took 9 seconds. At 9:21, the deputy removed the handcuffs. He did not speak directly to Cornelius. He returned to his vehicle. He drove away. Cornelius stood on the steps for a moment. Adais stood beside him. Neither of them spoke for a few seconds, which was the specific kind of silence that follows something that is both over and not over, that is resolved in the immediate practical sense, while being entirely unresolved in every sense that matters. Cornelius said, "You called the sheriff." Adais said, "I called the sheriff." He said, "Before you came outside." She said, "I called him while I was watching from the window. I wanted the conversation to be already in progress when I came out." He looked at her. He said, "How long did you have his number?" She said, 18 months. He said nothing for a moment. Then he said, "I have a deposition at 10. She said, "I know. Go up. I'll handle the next part." He picked up his litigation bag from where it had been set aside. He pressed the code. He went inside. He went to the file room. He pulled the document. He reviewed it. At 9:58, he walked into the conference room on the 4th floor and shook hands with opposing counsel and sat down. He was 2 minutes early. The next part, which Adais handled, took 41 days. The formal complaint was filed with the Tarrant County Sheriff's Office on the day of the incident, before noon. Adais wrote it herself, in the voice she used for legal documents, precise, sequential, without rhetorical flourish. Because rhetorical flourish in a formal complaint is the thing you add when you are not confident. The facts are sufficient, and the facts in this complaint were entirely sufficient. She attached the Texas bar identification card number and the firm's registration records and the building's lease documentation and the security footage from the exterior camera that had been recording since 9:12 a.m. She filed it, and then she called Cornelius's mother. Not to report, to tell. There is a difference. She told Patricia Vance what had happened and how it had been resolved and what the next steps were, and she said, "I wanted you to hear it from me before you heard it from anywhere else." Patricia was quiet for a moment. Then she said, "You had his number." Adais said, 18 months. Patricia was quiet again. Then she said, "Good girl." The investigation took 22 days. The deputy's body camera had been active. The footage was reviewed by the department's Internal Affairs Division. What the footage showed was consistent with what the complaint described. A stop initiated without articulable reasonable suspicion. A request for identification that exceeded the legal basis for the stop. A detention that continued after the identification had been produced, and the subject had provided a clear account of his presence, and a use of physical restraint that was not proportionate to or supported by the facts of the contact. The internal affairs finding was issued on day 22. The deputy was suspended for 14 days without pay and required to complete a mandatory training program in constitutional limits on law enforcement contacts. The department's Community Affairs Division issued a written apology to Cornelius Vance, signed by the sheriff, that used the words wrong, unjustified, and should not have happened. Not in the softened, hedged language of institutional apology, designed to acknowledge without admitting in direct language. Because the sheriff had reviewed the body camera footage himself and had seen what it showed and had decided that the language of the apology should match the clarity of the evidence. The apology was a matter of public record. Adaiz released a statement on behalf of the firm. The statement was 6 sentences long. It described what had happened, noted that the matter had been addressed through the appropriate channels, expressed the firm's commitment to the legal processes that existed for exactly this purpose, and ended with one sentence that Cornelius had written himself. "We intend to continue doing the work we have always done, because the work does not stop for the incidents that interrupt it." The statement was covered by 4 local news outlets and 1 national legal publication. The coverage produced 43 calls to the firm's main line over the following 2 weeks. 31 were from prospective clients. 8 were from other attorneys. 4 were from individuals who described incidents similar to Cornelius's and who did not yet know what to do with what had happened to them. Adaiz took all 4 of those calls personally. She listened. She explained what channels existed. She made referrals where referrals were appropriate and provided direct representation in the 2 cases where the facts supported it. One of those 2 cases settled within 6 months. The settlement was not large in dollar terms. The policy change that accompanied it was. The sheriff called Cornelius directly, 3 days after the apology letter was delivered. He called on a Saturday morning, not through a representative or a formal channel. He said, "I've seen the footage. I've read the complaint. I owe you a direct conversation, not a letter." He spoke for 11 minutes. Cornelius listened to all of it. At the end, he said, "I appreciate the call. What I need from you is not the conversation. It's the training program and the policy review that make the next contact different." The sheriff said, "We've started both," Cornelius said. "Then we're in the right place." He hung up and went back to the brief he was writing. The deposition from that morning had gone well. In the weeks after the incident, 3 things happened that no newspaper covered. The first was a conversation between Adaiz and a 3rd-year associate at the firm named Marcus, a 29-year-old who had grown up in Fort Worth and who had been at his desk on the 3rd floor when the incident happened, and who had watched from the window, standing beside 3 other associates, none of them speaking. He came to Adaiz's office on the Friday after the incident and said, "Can I ask you something?" She said, "Yes." He said, "How did you know to call the sheriff? How did you have the number, and how did you know that was the call to make?" She said, "Sit down." She talked for 37 minutes. Not about the sheriff specifically, but about the principle. The relationships you build in adversarial processes are tested by those processes, and if they survive, they become something useful. The phone number was not leverage, she said. It was a relationship. And the relationship existed because she had spent 18 months treating the man on the other side of a difficult case as a person who was capable of doing the right thing if the situation required it of him. She had not known she would need the number. She had stored it because the relationship had been earned, and earned things are worth keeping, she said. The preparation is not for the situation you can see coming. It is for the situations you cannot. You prepare anyway. Marcus wrote 2 things in the notebook he kept for exactly this kind of conversation. He had been keeping it since his first month at the firm, which was a practice he had developed after someone told him, in his first week, that the things the partners said in non-meeting settings were often more valuable than what they said in meetings, and that the practice of recording them was itself a form of preparation. He wrote, "The relationship is not leverage. It is a relationship." He wrote, "Prepare anyway." He did not show the notebook to anyone. It was the 11th volume. Itte casas. Itte. The second thing that happened was that the building's lease came up for renewal. Cornelius and Adais had been tenants on the third and fourth floors for 7 years. The building's ownership was a real estate investment partnership that had purchased it 4 years prior. The lease renewal conversation, which had been in the planning stages since July, concluded in November with the firm's acquisition of the third and fourth floors as condominium units, a transaction that converted them from tenants to owners, that removed the door code from the category of permission and placed it permanently in the category of right. Cornelius pressed the code on the day the transaction closed. He pressed it the same way he pressed it every day, without ceremony, because ceremony was not the point. The point was the pressing. Adais watched him do it. She said nothing. She followed him inside. The third thing was the pro bono case. 3 months after the incident, a man named Theodore came to the firm's pro bono intake. He was 44 years old. He had been stopped outside his own apartment building twice in the preceding year by the same responding officer in the same patrol zone. He had not been handcuffed. He had not been detained in the technical sense. He had been stopped and questioned and made to account for his presence on the steps of his own building in a way that had accumulated over 2 incidents in 12 months into a weight he was carrying that did not have a simple legal remedy, but that had a legal framework, and the framework was what he needed to understand before he could decide what to do. Cornelius took the intake himself. Not because it was his turn, the pro bono intake rotated among the associates, but because he had seen Theodore's intake form and had recognized what it described and had decided that the first conversation should be with someone who understood from the inside what the weight felt like. He spent an hour with Theodore. He explained the legal framework. He explained what was documentable and what was actionable and what was real, but not yet in a form that the system could receive. He said, at the end of the hour, "What happened to you is real. The law is not always fast enough or clear enough to address everything that is real. What I can tell you is what we can do and what the limits are, and you can decide what to do with that." Theodore said, "What would you do?" Cornelius said, "I would document everything. Every stop, the date, the time, the officer's name, the exact words said, the duration, the witnesses. I would document it the way you document a business expense, not because you plan to submit it tomorrow, but because the record is what makes the pattern visible, and the pattern is the argument. I. Theodore said, "Is that what you do?" Cornelius looked at him for a moment. He said, "I am the pattern and the argument both." Theodore left with a legal pad and a referral to a community documentation project that the firm had helped establish 2 years prior, which trained community members in the specific practice of recording law enforcement contacts in a format that was usable in legal proceedings if the contacts accumulated into something actionable. He came back 6 months later with 7 entries in the legal pad. The attorney who took his follow-up appointment was Marcus, the third-year associate who had been at the window, who had the notebook, who had written, "Prepare anyway." Marcus reviewed the 7 entries. He looked at the pattern. He said, "This is documentable." He opened his notebook to a new page. He prepared. On the day the building purchase closed, Adais went to the 4th floor after the firm had left for the evening. She stood at the window that faced Garrison Avenue. The same window she had been standing at on the September morning. The same angle of view. The steps were visible, the same steps, lit by the same street lamp that had been there for the 11 years before the incident, and would be there after. She stood there for a while. She had prepared for the call before she needed it. She had made the relationship before it was required. She had been at the window early enough to see what was assembling before it finished assembling, and she had been on the phone before she came outside. And when she came outside, she had said, I'm looking at him right now because the record required a witness, and she was the witness, and the witness was what the moment needed. She had not known she would need any of it. She had prepared anyway. The window faced the street. The street was quiet. The steps were empty. The building was theirs. Prepare before you need it. Build the relationship before the call. The ally you make in adversity is the ally you have when adversity returns, and it returns, and when it does, the phone should already be ringing. The thing I keep returning to is the 18 months. Not the phone call, the 18 months between a difficult case and a Saturday morning when it mattered. The decision to store a number that had been earned in a process that was complete. The understanding that the relationship was real even though the case was over, and that real things deserve to be maintained. Adaise did not store that number for this moment. She could not have known this moment was coming. She stored it because the relationship was worth storing. Because some things are worth keeping not because you can see the use, but because the quality of the thing itself is sufficient reason to hold on to it. And then the moment came. And the phone was already in her hand before she came through the door. Most people would have come outside first. Most people would have assessed the situation, decided it was urgent, and then looked for a number. She was already on the phone when she came outside because she had been watching from the window, and she had made the call before she was certain of what she was seeing, because she trusted what she was seeing enough to move before the picture was complete. That is not a coincidence. That is preparation. That is 18 months of a relationship maintained, so that when the moment arrived, the moment found the phone already ringing. Here is the question I have been sitting with, and I want the honest answer, not the one you reach for first. Who in your life is a number you have stored but not called? Not an emergency contact. Someone from a process that was difficult and real, and that left you on opposite sides, and that ended with a relationship that survived the opposition. Someone who knows what you are like when things are hard. Someone whose number is in your phone from a moment that tested something between you and found it still standing. Have you maintained that relationship? Or have you let the relationship retire with the case? One word in the comments, not the person's name. The word that describes what that relationship is, or was, or could be. One word for the thing that exists between people who have been through something real together and are still standing. Share this with someone who has a number in their phone they have not thought about in months. Someone who built a relationship in a hard process and filed it when the process ended. Tell them to call. Not because they need something, because the relationship is real, and real things deserve maintenance. Subscribe, because I am not finished finding the people who stored the number and built the relationship and were at the window early enough, and every single time I find one, the thing that made the difference was not the call. It was the 18 months before it. And next time, I want to tell you about a 59-year-old Barbadian-American civil engineer who spent 14 years as the only black senior engineer at a federal infrastructure agency, who filed one complaint, who lost, who came back and filed a better one with better documentation, who lost again, and who, on the morning the third one landed on the right desk, received a call from an oversight committee that had found the pattern in the records. Same story, different blueprints, same patient, precise mind that kept filing until the system ran out of ways to look away. I will see you there.